should a homeowner approach the board if their governing documents are silent? I think from a best practices perspective, yeah, reach out. Just shoot an email to the management company or the architectural control committee or the board and simply say, hey,
express your interest.
Well, say, I intend to install solar. What's the process?
Yeah.
Because you have to remember, too, they may have created a guideline or some sort of process that exists outside of the bylaws, or I'm sorry, not the bylaws, the governing docs.
Yeah.
So, I mean, it doesn't hurt to ask. And if they say, dear Fred, homeowner, nope, there's no procedure, get after it, good, you're in the clear.
And it's in writing.
It's in writing, which is one of our pro tips. Why not? It's one email. And you have to understand, too, when you install solar, it's pretty expensive. I mean, it's a pretty...
Well, depending on the program.
It's a large undertaking.
Yeah.
You know, it's not like you're just throwing up, something very simple in nature. This is a somewhat complex situation that you're installing on your home.
There's licensing and permits and lots of things.
And sometimes there's financing. I mean, it impacts a lot of stuff. So maybe take a minute and a half and send that email.
Yeah.
That'd be my first recommendation. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of L.S. Carlson Law. Welcome back to the show. Back today, we have Jenny Carlson.
Hi.
Welcome.
Thank you for having me.
And our producer, Marty.
Always a pleasure.
Thanks for being on, both of you. So last week, as you guys may recall, we went over failure to maintain, which is a huge area of concern, really, with most homeowners. And if you look at sort of the straightforward issues that don't really impact homeowners, it's small stuff, small areas in the community that are falling into a state of disrepair. Mm-hmm. They don't have massive consequence. But then you run the spectrum and you're in a Surfside situation, which was an absolute travesty.
Yeah.
It was tragic. So we really talked about that. We talked about how bad these things can get at the worst side and what homeowners can do to protect themselves and enforce their rights. So today is interesting. Today is solar disputes.
This one is interesting for sure.
Yeah, I actually really love this one. And I love it because it's very unique legally. It's unique because, when we look at HOA, there's sort of these common themes of negligence, breach of contract, breach of fiduciary. The solar issue throws a whole new curveball into the world of HOA law. So, Marty, where would you like to start with solar disputes?
Yeah, so I want to talk about, since running in on that theme, there's a lot of gray area in here because solar is relatively new in terms of HOAs. HOAs have been established for a long time, decades, and they usually have CC&Rs that were written decades ago. Right. But solar is very relatively
cutting
new,
edge.
But and there's laws that are passed and there's things that are going on there. So you're in this this push-pull between the homeowners wanting to put solar on their house, but CC&R say, well, you have to have a certain paint, but it might not be in the CC&R, so you've got this power struggle or tension. So
and so many incentives for solar as well. Yeah. And I always wonder, those solar incentives, whether they're at the county level, the state level, I get so many mailers, you name it, phone calls even about installing solar.
Yeah.
And so I just wonder what that gray area.
Well, let me start by saying you almost have to look at solar situations in 2 camps. One, the tension between an association and the homeowner. Homeowner wanting to do the right thing, install solar, association coming in and saying no. It violates the CC&Rs, or there's some sort of conflict between the governing documents of the association and the homeowner wanting to put solar in. That's sort of issue number one. The secondary issue that we see, though, is assuming you get the solar panels in, a ton of conflict arises between the homeowner and the solar company who installed it. So it's very interesting to see the disputes that arise, right? And I always, I empathize with the homeowner because typically homeowner is just trying to do the right thing, maybe for the environment, maybe for economics.
Yeah.
They say, hey, you know what? This is going to be good for our family because it's going to cut down on energy bill, cut down on the energy bill, and it's good for the environment. And all of a sudden they get friction from the association.
Yeah.
And sometimes even when they don't, they realize they bought a bill of goods, or you know what I mean? It's equipment that doesn't work, or it's faulty, or the installation resulted in water intrusion issues.
Or it's such an eyesore. I saw a house the other day that had solar on their shed. They had so much solar that it truly was a solar overload and needed to be stopped.
Well, that's almost where you get into the issue more when the association pushes back.
Right.
Yeah.
Right, more so than the functionality and whether or not it works.
Right.
So, Marty, between those two camps, where should we start, and how do you want to sort of navigate this?
So I think it's important to recognize, particularly here in California, we have relatively new laws that protect or incentivize solar. Is that not correct?
Yeah, so relatively recently, California said, in their wisdom, they said, hey, solar is going to be great for the state.
Yeah.
So they really incentivized people and encouraged people through different programs, tax programs.
All kinds of different incentives.
To install solar. And so what you saw was this huge push in California for solar. Now, interestingly enough, you had some really good actors and good players who came in, sold solar, did it right, installed them perfectly, really a non-issue. And then you had a whole bunch of bad actors as well, which really falls into that second camp. There's a lot of fraud in this space.
Yeah, and there's a lot of interesting tactics by them taking, the leasing programs and this other stuff where people feel somewhat bamboozled. Oh, I don't own the house. Well, then you go to sell the house, and it's like there's a lien because of the solars on your house. So there's a lot of malfeasance.
A lot of malfeasance and a lot of greed that took over. And so you have that sort of situation on the other side of things. But on the homeowner association side, what you saw was homeowners hearing about these programs, wanting to take advantage of these programs, and getting tremendous pushback from the association. Mm-hmm. Or you had bylaws and CC&Rs that were really antiquated when it came to the new push towards solar.
Can I ask a very basic question?
Yeah.
If a solar representative came to my door, knocked on it, sold me, I'm 100% hooked, great, I want this, do I need to get HOA approval? Does that depend on my CC&Rs?
It does depend, but I would
question.
say 90% of the governing documents that we see, you have to run it across at least the Architectural Control Committee.
Oh, interesting. Okay.
Because you got to look at it this way. It's a fundamental change of the property typically, right? Because it exists on the roof and
for sure.
often people can see it.
They joke about a red door being an issue. I mean, talk about
right,
panels.
and it's very similar. You're actually changing something permanently.
So when I've done a little bit of research into this, the interesting one comes when, we'll get to the muddy waters of the laws, how it contradicts the CC&Rs, but people think that, I don't need to get approval from my board. The panels are going to be on the back of the roof anyway. But then the HOA still has a problem with it.
Yeah, and what you're going to find is, the general way of looking at it is the association is permitted to give input. The association can say, you know what, ideally we don't want them there. We want them somewhere else. And so long as there's really not a huge impact in terms of cost and in terms of the installation, generally those recommendations are going to be enforceable. The problem that you typically run into is one where the association says no solar. Okay, that's going to be problematic for the association.
Sure.
Or, hey, we want you to do something that's unreasonable and very challenging to accommodate. So, for example, you want the solar panels on a certain part of the property, and the association says, no, we'd actually prefer them over here, but over here is a logistical nightmare, and it's going to cost a lot more money to install.
Or there's shade. It doesn't provide the efficiency.
Okay, that's true too. Yeah. So that's really what you're looking at. Now, if it's a reasonable accommodation, if it's slight, if it's subtle, if it has a de minimis impact on economics, that's typically going to be okay.
Yeah.
Well, let's back this train up just a little bit, because let's say like most houses that are in HOAs, primarily 80s, 90s, in your 2000s, and then your 2010s, people start becoming a little more hip to solar. So let's say we've got 3 decades of CC&Rs that have no provisions for solar.
Right.
They don't
No verbiage
exist.
whatsoever,
No
yeah.
verbiage, because who would have known? So
Hip to solar. I'm going to steal that. I really like that.
So at that point, what do you do? I mean, if a homeowner goes around and say, well, there's no provision for it, I'm just going to put them up. Or do you ask? Or there's a lot of gray area there.
Yeah, no.
Like, at what point is it the HOA for them to take action and update those CC&Rs to accommodate
Well,
solar?
best practices is that the association should at least somewhat consistently be updating CC&Rs. Best practices. And I say that because what happens is if you're not doing that, you're going to find more controversy in a community.
Is the hope that that's on like a yearly basis?
No, not yearly. Yearly would be, I think, too much.
Okay.
It'd be a huge legal bill, too, to constantly be updating. But, I mean, at least every 5 years or so, or at least amend, or
That's
when there's
within
major
reason.
overhauls to law,
Yeah.
it's not a bad idea to come in and update.
Yeah.
You know, the biggest cases that we see in terms of problems is where I sit down with the client and they have the CC&Rs drafted in like 1983.
And they
Okay,
haven't
that's
been updated
problematic.
since.
It's often on a typewriter.
Yeah.
It's just they're a mess. They're in shambles, and it results in huge problems within the community because there's an ambiguity with respect to the relationships of,
course, yeah.
the parties. So, you know, best practices is, you know, maybe at least every 5 years. You know,
Okay.
there's some associations that are very on it, very consistent, constantly updating. That I think that's great. So again, though, the issue that you were identifying, Marty, is where you have these antiquated governing docs that don't even contemplate solar, rightfully so, because it didn't exist at the time.
Sure.
So
Yeah.
what do you do? So your question was, should a homeowner approach the board if their governing documents are silent? I think from a best practices perspective, yeah, reach out. Just shoot an email to the management company or the architectural control committee or the board and simply say, hey,
Express your interest.
say, I intend to install solar. What's the process?
Yeah.
Because you have to remember, too, they may have created a guideline or some sort of process that exists outside of the bylaws, or I'm sorry, not the bylaws, the governing docs.
Yeah.
So, I mean, it doesn't hurt to ask. And if they say, dear Fred, homeowner, nope, there's no procedure, get after it, good, you're in the clear.
And it's in writing.
It's in writing, which is
Yeah.
one of our pro tips. Why not? It's one email. And you have to understand, too, when you install solar, it's pretty expensive. I mean, it's a pretty...
Well, depending on
yeah.
the program.
It's a large undertaking.
Yeah.
You know, it's not like you're just throwing up, something very simple in nature. This is a somewhat complex situation that you're installing on your home.
There's licensing and permits and lots of
and
things.
sometimes there's financing. I mean, it impacts a lot of stuff. So maybe take a minute and a half and send that email.
Yeah.
That'd be
Yeah.
my first recommendation.
Perfect.
Okay, so let's get into the nastier stuff when
Okay.
it gets a little more murky. California came out with the Solar Rights Act. Okay, so what happens when the state law contradicts what the CC&Rs say? So it specifically says and incentivizes and tries to lower the barrier to allow for people in these types of situations to install.
Yeah, you know,
At what point are you fighting against your HOA saying, hey, the law says I can put this up,
Yeah.
but you're saying I can't?
in most cases, state law is going to trump CC&Rs.
Are there situations where it might not?
There are, but not really applicable to solar and what we're discussing. So look at ADU, for example.
Okay.
Right? There was a huge push in California to encourage ADU because of the housing crisis.
Yep.
Yeah.
It was wonderful, and they made really the installation of an ADU within an association much more user-friendly than it had been historically.
Yeah.
And so when there was conflict there, 9 times out of 10, the homeowner is going to get the ADU,
Prevail.
even if the association pushes back. Very similar to solar. Now, here you're leveraging state law and really the general public policy that favors the installation of solar. That's what you're leveraging against an association. Now, again, the association does have some rights. It's not to say that they're without rights and you're just going to steamroll them.
Yeah.
The association has certain, they can push back on certain things so long as it doesn't become an unreasonable burden on you who wants to install the solar. So that's really where the tension is. Now, if it was a hardline no, it's going to be very challenging for an association to keep that position if you attack it legally and you
Got
attack
it.
it correctly.
Now, in your experience, do you ever see in the CC&Rs where they put, we'll call it somewhat draconian like measures in to where it's within the realm of the law, you can put it in here, but we're going to make it nearly impossible?
I haven't seen that. I haven't seen an association hell-bent on stopping solar, because that's really what it would require, right? Someone who really doesn't want solar.
Well, then that goes back to a bad, maybe a couple bad apples of board members, right? What if you just have a tyrant says, I don't want my Tudor-style homes, that my multi-million-dollar Tudor-style homes have a bunch of ugly solar panels on the front of them. I want to maintain the architectural integrity of the neighborhood.
So, overall, in general, the law sort of understands balance between the two.
Yeah.
An association, their rights to maintain harmony within the community, the aesthetics, and the public policy that favors solar. So that's sort of the two sides of the coin that you're balancing. But what's going to happen ultimately is homeowners tend to prevail when they want to install solar. If you have a tyrant who says no solar, you can't put it in, eventually if you articulate it correctly and if you enforce your rights correctly under California law
and proper communication,
you're going to get the solar in some way. I mean, that's generally the case.
Yeah.
Barring certain circumstances, of course. But yeah, I mean, the tyrant isn't going to be able to, he's going to die or she's going to die on that hill.
Sure. So at one point, it's gonna come rolling around,
and that's simply because California favors solar right now.
Right.
Yeah.
And the laws have been designed.
We live in a very pro-solar state.
Yeah.
We do.
Yeah.
And we're also in a very pro-ADU state as well. So there's certain things that California has recognized as important, and you're going to be able to leverage that against, for example, a tyrant who says no solar.
And but they could still make your life a living hell just by
they can, absolutely.
Even just like kicking the can down the road.
Yes, they can run interference on that.
This is a broader question, but when they modify the CC&Rs, because in most situations I would assume at some point there's going to be provisions for solar in just about every HOA. Do the homeowners have to vote on that in terms of the architectural? The way it's placed, or any amendment to the CC&Rs, does it come to a vote?
So you're always looking at governing documents. It depends. I know I use
like
that
the bylaws
a lot.
will specify.
You'd have to look at that and sort of determine whether or not it requires a vote. Every community and association is set up a little bit differently.
Okay.
So go to your bylaws, review that, and see what is required. Because sometimes it is, and other times it's permitted by way of the association.
I think we've already answered this question, but I think it was just want to clarify. Is there a law to specify when a state law or new law comes up that trumps the CC&Rs? Is there a law that says that you have to update at a particular time?
No, there's no specific law that I'm aware of that requires you to update the CC&Rs. Right? Because how it works a little bit differently. So let's say I have CC&Rs from 1973. Or 83 or whatever. Those are fine unless state federal law comes in that's different and contradicts. And when you have a contradiction between the two, state law, federal law is going to trump automatically.
It seems like just with laws being amended and changed, you would naturally have to have at least somewhat decently updated CC&Rs.
But it defaults to the prevailing law automatically.
Yeah.
So if you have a law a CC&Rs that says something completely inconsistent with state,
yep.
State's going to win. So it's not necessary per se to have to go in and retool that one line.
Yeah.
By default, it defaults to the state law.
But I feel like in this situation, that just makes the whole thing worse because you've got state law. You're coming in there and saying, state law says I can install these here on my roof because it's a certain efficiency and they say I can put it in. You're telling me I can't. And now there's this friction. If there was a law, just let me finish rambling. If there was a law that says every 5 years that your CC&Rs need to be updated, wouldn't that solve a lot of potential issues?
I think it would. Maybe the pushback there, and I'm not trying to play devil's advocate on this, just thinking out loud. You might run into situations where a association that's very small and is running on a shoestring budget may not be able to afford the legal. Even if it might be kind of cheap to do it,
yeah.
It's still an expense.
Right.
To have a lawyer come in, because you're going to need a lawyer to amend CC&Rs and follow proper protocol.
Don't they have those on retainer though? Like, aren't they like retained to?
Yes, the ones that have money. But you got to remember,
Oh,
there's associations that are not, in Newport Coast that are,
Understood.
that have huge sums of money. There's some very small associations that are 4 units.
Sure.
Or 5 units,
that
or 6
makes sense.
units, or it's low income. So you have to sort of balance the economics there too. And if it automatically goes back to state or federal law automatically, I mean, ultimately, even if you don't amend it, the homeowner still has rights and it can still enforce.
Sure.
Yeah.
So it's not necessarily a barrier for the homeowner if their rights are being trampled on, because they can enforce vis-a-vis state law, even if the CC&R say something different.
Sure.
So, and I don't know the logic behind it.
Yeah.
You have to go to the government level and kind of see why that's not the case. But in my just knee-jerk reaction to it, practically speaking, it would put a financial burden on most associations if they were required to update their CC&Rs over every specific period of time. I mean,
they specified how many units before that kicks in.
maybe so, and there might be ways to accomplish it. But I'm kind of dealt with the hand that I'm presented with.
Well, it's kind of interesting too.
Become a
because,
lobbyist.
You're right.
Right? I just think of a few friends, and I've had so many different experiences just with chatting with them, where I look at a neighborhood like mine where we have a really great HOA, but every home is different. So I feel like there's a lot of freedom within our solar rights, if you will, because
Yeah.
every home is different, every roof line is different. Where I look at a neighboring community that has very cookie cutter homes, the big, large cookie cutter homes, but they're like, model A, model B, C,
Sure.
and D.
Yep.
And they get so specific in their CC&Rs. It's like model C can only have them on that front right roof line. Like it's so specific where they can install solar. It's very interesting.
That's more modern, though. You're looking at
No, for
more
sure.
modern communities that have been around, have kind of seen situations go bad, and they've learned from that. So if you
Yeah.
look at newer developments, they are more sophisticated. Their CC&Rs are more sophisticated. Their CC&Rs are more dialed in, and they're actually prepared better than what you saw even in the 90s or the
I
early
bet.
2000s.
Yeah.
Because there has been sort of this educational curvature, right, where they've leveled up. Now, that doesn't mean that new developments don't have problems, because they do. But the level of sophistication has increased when it comes to drafting CC&Rs.
Makes sense.
Absolutely.
Okay, so let's get into the disputes, because this I think breaks our chain a little bit. Oh, you tell me of how when a dispute arises, you're already knee deep, likely that you've already installed solar at this point. So I think there's 2 disputes that you might encounter. Number 1, you've installed solar, you've got the permits. You went through all the proper local channels. You follow the state guidelines. You install it, and then HOA says, "Wait a minute, I did not approve those." But the homeowner says, "Well, that wasn't in the CC&Rs. I looked here. I follow all the guidelines, the paint guidelines, this guideline, this guideline. There's nowhere that talks about solar. I didn't think I needed approval."
Right.
And then you've got the people that want to install it, where the HOA is stonewalling you and saying, well, you can't install it at all, number 1, or maybe you can't install it where you want to install it.
Right.
So I think there's like 3 layers of dispute types that all have probably a different approach that you might say, hey, this, if it's for A, you go this way, you go B this way, but maybe you can shed
you
some
might
light.
actually have 3. So you have before you start the installation,
Yep.
you're in the application process, or somewhere in that land where you got denied.
Yeah.
Yeah.
Or they're putting up barriers that are unreasonable or economically outrageous.
Sure.
Okay, so that's 1. 2, you're sort of midstream. You're in the process of installing, and you get a stop work order.
Yeah.
Oh, yeah.
That's fun. And then 3rd, it's installed, and now they're going in after the fact. Maybe they're telling you to rip them out.
Yeah.
So I would argue that on balance, probably the first case scenario is probably the best case scenario to be in.
For
Yeah.
sure. You didn't already blow money and
Exactly,
contractor time.
Right. So, if you're in that first phase, the IDR might be the way to go, just to get everyone on the same page, get the board sitting down. And again, IDR is informal dispute resolution. We discuss it fairly consistently on the show, but in California, it is a great way to resolve a dispute before it really becomes a dispute.
Yeah.
In my mind, it's effective. It should be efficient. the spirit behind it is the board's coming down. They're working with you, hopefully in good faith. So I like the IDR play early on.
Early on?
Yes.
Okay.
This is where you send the application in, they've denied it, or they're giving you some parameters that are just outrageous, like I said.
Okay, so back up. You would say to put it in front of them first, informally. You wouldn't just call IDR. You would say, here, I put it in front of them. They stonewalled me. They ghosted me, or they denied it on some unreasonable grounds. At that point, immediately jump to IDR.
I would,
Okay,
because
perfect.
Arguably, you've kind of ran through this initial phase of back and forth. You've presented something to them. You're in communication with them. They've made an affirmative decision of no, or an affirmative decision of jump through all these hoops. So at that point, kind of going back to them, having conversations with them might not get as much traction as a more formalized sit down under the umbrella of IDR. So I actually think IDR would make a lot of sense at that point.
Okay, so let's back that up a little bit too. So even so, we want to document everything.
Yeah, well, we can go through our flow, which we've yet to create an acronym for.
Yeah, I know,
but yeah, so.
And it adds an extra layer of complexity. So number one, document everything. Send it all to them ahead of time.
And you should already have a lot of it documented,
Sure.
because typically you've already submitted some sort of application.
Some sort of written
you have
request.
back and forth. They've probably denied you in writing or created a whole bunch of new parameters. So you probably already have a good amount of documents going into it.
Number two was know your CC&Rs. So find where the gaps are, or where it doesn't, it doesn't say anything, and where they're potentially saying this is in the CC&Rs where we're kind of enforcing.
Yeah,
under
familiarize yourself, because ultimately
Absolutely.
that's the ammunition that you're going to need to have the conversation.
But a third one that's interesting that doesn't apply to the rest of them is, in California at least, the new laws of the Solar Rights Act. So wouldn't you want to have some sort of some sort of knowledge of that before, like if you're about to go to IDR, shouldn't you have some sort of knowledge on that particular law?
Solar Rights Act, SRA. I would even go as far as print it out.
Yeah, applied knowledge is power. If you have that at your fingertips.
A lot of these cases, obviously Davis Sterling is a huge component in most of our disputes. Davis Sterling is so powerful.
Yeah.
But now we're in sort of this newer area where a newer body of law came into existence.
Yep.
Right? So yes, if you can go into that, understand it, and bring that in addition to all your other paperwork and your understanding of your CC&Rs, you're going to have strong footing.
Yeah, absolutely.
To have a real conversation.
Go in prepared.
And, again, these are situations where forget emotion. This is just off the papers.
Yeah.
It's more mathematical, right? You're almost running them through a
I feel
mathematical
like that's part
equation.
of your key to life.
It's a key to everything.
Yeah.
Unless you're an actor, maybe, right? Then it's a different story. But when it comes to business, because ultimately this is it's a business conversation.
It's true.
You're dealing with contractual obligations. You're dealing with legal rights. Come at it that way. Approach it as if you're playing Monopoly. Can you sell the house or can you not? Or what are the rules? What are the parameters? Can you put another hotel on?
Stop buying my damn hotels.
Yeah. And
he beats me every time I buy hotels.
I'm actually good at Monopoly.
He's a freak in Monopoly. A freak.
I bankrupt everybody.
Yeah, it's ridiculous.
So anyway, come in clinically, and the more power you have or the more knowledge you have, you should be in a good position to have that conversation.
So then we go there. Then we go to the IDR. I'm assuming this follows the same pattern. If you get nowhere with IDR, is that our trigger to calling a lawyer?
Then you're talking to a lawyer.
Yeah.
Okay.
And the lawyer might be able to look at the nuances of it.
Our phone number is.
But yeah, lawyers make sense at that point. And honestly, looking at the two other situations where you're midstream in construction, or you're post and you're getting some sort of violation notice, you could always run IDR as a starting point for that under the same sort of theory. You have the act ready to go, you have your governing documents, and you're having that conversation.
I would say it's much more serious at that point because you've literally, dug the
exhausted
hole.
everything.
You're already midstream. That's almost frightening in a way.
It's more serious, but it's not a bad option to still run before calling a lawyer.
Yeah.
Yeah, for
and
sure.
Listen, I get that lawyers typically say, call us immediately, do this right, get us on the phone. I get that to an extent, but if you think that there's a potential for some sort of resolution without a lawyer, maybe your association just doesn't understand the Solar Act.
Yeah.
Maybe they just had a knee-jerk reaction to it. And again, I'm not saying delay, spend months and months trying to get this process worked out, but I don't think it's a bad option to at least try IDR within a short time frame to resolve it, and then if it doesn't work, then find lawyer up.
Yeah.
Yeah.
And a good lawyer can move very quickly on this.
Yeah.
They can slot in, fire off whatever demand letters are appropriate. It might be a demand for ADR, which is alternative dispute resolution under the Davis-Sterling Act.
That's where you get an arbitrator. Is that right?
Well, no, not an arbitrator. Typically, if it's ADR, it's a mediator.
It's a mediator.
And the difference between mediation and arbitration is mediation is a negotiated resolution, if any resolution.
Sure.
Meaning, even if the mediator agrees 100% with your position, the mediator cannot compel nor force the other side to resolve the dispute. Arbitrator, on the other hand, can.
Okay.
Now, not to get too nuanced, but there's non-binding arbitration, there's binding arbitration, so there's different forms of arbitration.
That may be another episode.
Yeah.
But that's a whole different episode. It doesn't apply here. What I'm talking about is ADR, which is really just mediation.
Sure.
Okay.
And a good lawyer can move in very quickly on that and also assess whether ADR makes sense or just a straight demand letter makes
Yeah.
sense.
So just to recap, exhaust all of your options first before needing to lawyer up.
Regardless of what camp you find yourself in. You might find yourself in the early camp where you're just getting a denial before installation. You may find yourself pre-installation, or not pre-installation, sorry, mid-installation, and you're getting some sort of stop work notice, or you're post-installation and you're getting lit up. Right? These are all the variables.
You need after the fact approval.
Well, that's scary because, I mean, we'll get into the Reddit story, but if you incur $500 a day fees while that sucker's still up there, that's a frightening situation.
Well, the other situation, which is interesting, and I'll talk about briefly, is you have an awesome association. They say, go at it, install, we approve. That went swimmingly well. And you get a bad situation with the solar company, right? The solar company sells you a bill of goods, meaning they say, hey, there's a certain amount of wattage that we're promising you or sort of benefits that you don't receive after installation. Or there was misrepresentation, or there was some sort of damage to the property during the installation.
Oh, interesting.
So solar almost becomes two types of disputes. One potentially with the association during the installation process.
Yeah.
But then even if that goes well, we see a lot of disputes directly with the solar company.
Interesting.
And that's interesting because it kind of it falls outside of association land.
Yeah, for
Governing
sure.
documents don't matter.
CC&Rs don't matter
It's a totally
anymore.
different ball of wax. And really what you're dealing with there typically is often a breach of contract claim, negligence claim,
Is there misrepresentation?
misrepresentation or fraud.
Yeah.
Because what you see is, you have these people going door to door and they will say, hey, this is going to be the best thing ever. It's going to save you millions of dollars and some kind of, ballooned sort of savings. And it doesn't come to
I
fruition.
always have a nice collared shirt.
They always look very sharp.
Yes.
They have a clipboard. They look official. And it's just horrific. It's a nightmare.
Yeah.
So these things can become tremendous nightmares. Or they, in the process of installing it, they damage your roof and a storm comes and you're flooded. So it's a very interesting type.
There's water intrusion.
Well, yeah, it's a water intrusion issue.
Yeah.
But those are interesting cases.
Would you call this under the guise of a contractor dispute?
Well,
Partially, I guess.
it's part contract. Well, it's big part contract. It's typically breach of contract. If they hire contractors to come in, now you're under some sort of contractor dispute. There might be misrepresentation or fraud. So even if it's installed perfectly, then it's not a contractor dispute, but now it's some sort of misrepresentation. So you get all these variables coming out of solar.
Interesting.
It's become a very fascinating world.
We need to do an episode just on the contractor outside of HOA or the contract. That's a really interesting, because this is a complex one.
It is. And then you're dealing with, and then sometimes it gets even more complicated because you've now spent money, or I'm sorry, you didn't spend money. You have a financing company that's paid for it. So now you're tethered with them, right?
Right.
So it's almost like akin to you buy a car that's a lemon, but you finance it through a third party.
Yeah.
And now you're just in a whole mess because the car's not working. You're paying the finance company still because you're under contract with them.
Yeah.
So where's your recourse? And then what's interesting, you brought up arbitration. A lot of these solar contracts have arbitration provisions. So how do you? You don't always have the option for mediation.
Yeah.
So logistically, to run a solar dispute can be complicated.
So it is very important to make sure you have a solar company that is reputable.
Absolutely.
Okay.
Yeah, and even the reputable ones screw it up. I've seen. So
Or still kind of try to screw you.
Yes.
Okay.
Yeah,
Episode on that.
You open up a can of worms.
Like, because that one's interesting.
Yeah,
You just added 4 more episodes, Luke.
Yes.
Well, at least in the official podcast or the other
that
podcast
might be
we
a
have.
good
I
for.
think it's a great episode.
All right.
Okay, hold on. Before we get to the Reddit thing, I would like to know, because it's kind of interesting. In this context, would you sue for legal fees? Because here's the thing, there might not be damages like necessarily, right? Or the damages. I mean, you can argue.
Are you talking about the solar disputes?
The solar disputes.
Okay,
Yeah.
so
yeah.
you
So getting back to it, let's.
You're
I guess
interesting. You want me to tease this one?
Point the laser right to.
He knows exactly what he's doing.
If we want to point the laser right back to the dispute in the context of a homeowners association between the three that we were talking about, pre, during, and post. If you brought in a lawyer, I mean, if you haven't installed, there's no damages, right? So, but now you're incurring legal fees on top of that.
There can be damage because there's that loss of use opportunity. It's not loss of use. It's you're not gaining the benefit of the bargain, right? So you come in, you're supposed to get these savings for the solar, and they shut you down. Well, there's you lost money there.
Okay, interesting.
Attorney's fees also become an issue too.
So you would potentially, sue for attorney's fees at that point.
I mean, every case becomes a little bit different,
Sure.
right? But if they're stonewalling you, I mean, arguably that becomes some sort of breach of fiduciary by way of the board if they're trying to stop you from doing something that's you're lawfully entitled to do.
Yeah.
So that can become an angle to go after attorney's fees, but there could actually be damages associated with the delays of the project, the benefit of the bargain. So, everyone has to be scrutinized under its own set of facts and sort of what the damages are. But a good attorney will sit down with you and sort of pen or pencil out, hey, this is what you're looking at in terms of potential damages. Then you're analyzing it not from a legal perspective, but you're analyzing it from an economic perspective.
Right.
Sure.
Because you have to understand too, sometimes you look at a case and legally speaking, there's a breach of fiduciary, there's a breach of CC&Rs, and the breaches are very tangible, but the damages are so de minimis, bringing in a lawyer makes no economic sense.
That's where I was kind of getting at with this whole thing.
And that can be the case too. So a good lawyer analyzes both. They look at the economics, they look at the legal, and then they present to you, the potential client, a decision which is a business decision ultimately. Right?
No, that
and,
makes sense.
and that's what a lawyer's job is. Here's the pros and cons. Here are your options. If you want to enforce, this is what it looks like. This is what we estimate it to cost. And then they make a decision based on that.
Yeah.
And, with any sort of legal situation, there's no guarantees of outcome.
Sure.
Because you can have a perfect set of facts, you can have a perfect set of law that supports your position, but your job as a lawyer is advocate. You are advocating on behalf of a client. You're enforcing their rights, but ultimately you cannot wave a magic wand and have someone do something different, right? You can influence it, you can put pressure on, you can be hyper aggressive, but ultimately it's a human being.
Right.
And rightfully or wrongfully, if the board says no kick rocks, well, okay, then it becomes a bigger battle.
Yeah.
Yeah.
So that's my 2 cents on that.
I'm excited about this Reddit.
Yeah.
You read
Okay.
ahead? All right, who's
Reddit
reading?
rapid fire.
Jenny always reads it. She's always the one.
I'm
All right.
open to.
All right,
no,
go
I
ahead.
can't. I'll go mush
I'll
mouth
just
on this
listen.
thing.
Are you just going to listen? Okay.
Yeah, I'm not even going to read it.
Here we go. HOA fines us $500 a day for solar panels, even though they're legally protected. So I'm sure some of you will appreciate this insanity. My partner and I live in Pleasanton, California, and decided to install solar panels to do our part for the environment, reduce our energy bills. We went through the proper channels, got all necessary approvals and permits from the township, and installed everything legally. California even has a law protecting homeowners who want to install solar panels. Perfect, right? Not according to our HOA. As soon as the solar panels went up, the HOA started sending us notices demanding that we take them down immediately. They claimed that our panels violate their aesthetic standards, whatever that means, and threatened the uniform look of the community. Never mind that the panels are mounted on the roof where you can barely see them from the street. They even had the nerve to say that the panels could affect property values. Give me a break. Things quickly escalated. The HOA started fining us $500 a day. You read that right, $500 a day. We pointed out that California law actually protects homeowners like us who install solar panels. But they ignored us and doubled down. I guess they're either stubborn or just enjoy making life miserable for no reason. After we sent them a letter referencing the California Solar Rights Act, the HOA didn't back off. Instead, they tried a different angle. They claimed our solar installation violated a newly enforced rule about roof modifications, saying that any changes to the exterior of the home, including solar panels, required their specific approval, even though we had already received all the necessary permits from the city. They argued that our panels interfered with the architectural harmony of the neighborhood and required us to submit a new design that would be less visible from the street. Let's see. They pushed for us to move the panels to a less effective area of the roof. Effective? Is that grammatically incorrect? Knowing full well it would drastically reduce the system's efficiency. What are my legal options?
I missed something. Did they just move forward with the solar panel installation because
they kind of glossed over it? They said that they got all the proper permits.
They got permits, but did they? So my first question would be whether or not the CC&Rs required any sort of application process.
So my read on this, when I originally read it, was their CC&Rs don't say anything about solar. The California law says you can have solar.
Yep.
They got the permits since it wasn't on the CC&Rs. They just assumed this is, I think, where it all fell apart. They assumed it would be fine. They went to the city. They got permits for the solar. City said no problem.
Okay.
They installed it, and then after the fact, then their HOA threw a fit about it.
Here's where they glossed over it. They said we went through all the proper channels, got necessary approvals and permits from the township.
Yeah, they didn't say anything about
They didn't say anything about HOA.
I think they
So first and foremost, the 1.5 minute email would have solved a lot of the problems that we're seeing here.
Yeah.
Sending that email to the management company or the association asking what the procedure is would have, I think, sidestepped maybe a lot of the headache.
100%.
Potentially. Now, regardless, putting that aside, assuming that they didn't get the proper authorization, the association now is going so far to fine. So, this could be one where you almost sidestep IDR because in my mind, they're making a pretty aggressive move, even after being educated.
Yeah.
So this almost seems like a battle of wills more than incompetence. Because incompetence, you can generally deal with through education.
Sure.
Yeah.
And those aren't horrific. I mean, you kind of go in, you educate, typically through a legal letter. And
They seem somewhat reasonable.
yeah.
Although they're not malicious.
Right.
Typically just
This
ignorant.
seems like there might be a little bit more beneath the surface. There might be some bad blood here. So there's interesting plays that they could run. One would be a demand for ADR, for alternative dispute resolution, stating that the fines in and of themselves are illegal because they're enforcing in a way that's inconsistent with state law.
With state law.
Okay. So ADR might be an appropriate play. And if the association was forced to bring in a lawyer, the lawyer might look at this and say, what are you guys doing? You need to back this off. Let's, erase the fines and sort of create some sort of harmony in the situation. That'd be a good lawyer. The other alternative, which is a little bit more risky, and again, we're not giving legal advice to this person. This is a hypothetical, but it would be an interesting strategy for them to pay the $500 a day. I didn't catch that as a day. That's obnoxious. You almost pay it under protest, and before it gets to the $12,500 mark, sue in small claims for that money back. Now that's risky because you're bringing it to small claims, and small claims can be an imperfect bench, meaning you get some weird decisions. I don't love that one. That's risky, but in theory, that could be another channel to approach it.
If they lost, the homeowner loses in small claims, does that set the precedent that they were like?
Well, yeah, it just becomes that much more complicated.
Yeah.
So, on balance between the two, ADR seems to be a very viable path on this one. I think that would probably be the recommendation. The alternative is you just get a good lawyer to write a very, very aggressive demand, articulating the act, the power of the act, what's happening here seems to be inconsistent with that and inconsistent with public policy that favors solar.
Yeah.
And see if a resolution cannot be met between the attorneys. Because once, you got to realize too, once a lawyer sent a letter to an association, often an association attorney appears on the other side.
Yep.
Not always, but more often than not.
Yeah.
And that
And it sounds like this HOA more likely than not has an attorney.
And they might. I don't know.
Only because of the fine. It feels very aggressive.
It's hyper aggressive.
Yeah.
But I mean, 500 a day is tremendous. But that might be a way to get traction and also get an adult on the other side to emerge, look at this, and hit a resolution. Because right now, as I see it, the homeowner is just on the receiving end of that punishment. And they're not really doing anything other than just getting kicked in the face every morning with a $500 bill. So the dynamic needs to change, and you have to do that through enforcement. How do you enforce? Again, you can go IDR. IDR might be a little soft given the situation.
Yeah.
An aggressive
ADR
nature.
might be an appropriate measure because, again, once an ADR demand is sent to an association, they have 30 days to respond. It triggers legal obligations on their end. So it knocks them on their heels pretty quickly. Or a very well-worded letter to the association articulating the rights. And, I don't have all the facts here.
Sure.
But assuming that they are correct, that what the HOA is doing is inconsistent with the act and state law, a well-reasoned letter to the association that might be received by the association council might get this thing resolved.
Yeah, I like that.
There you go.
Interesting.
That was a fun one, though.
Bada bing, bada boom.
All right. So what
That's
now?
it for the series.
That's it?
Ooh.
Series is done. Wow. All right.
We have some very fun and exciting episodes to come.
Oh, yeah? What do we have, Marty?
We have a Reddit AMA that's going to be coming out. So we're going to post in the same place that these are posted, saying on behalf of you, say, I'm Luke Carlson,
Give me your worst.
lawyer, an HOA lawyer based in California. Ask me anything. And the whole episode will be looking at all those questions.
That'll be fun.
And some of
I've
them-
never done that before. That will be very interesting.
Hopefully, and we'll try to edit out the how do you live with yourself, like lawyer ones.
Oh, that would be good. Yeah. I'm sure there'll be a lot of, I'll look forward to that, though. I kind of enjoy that
I
stuff.
figured you would.
All right. Very good. Well, thank you guys. I think that was a tremendous season.
Yeah,
You call it a season?
We'll call it a season.
We'll call it a season or a series.
All right. Tremendous series. So thank you both. And
was
thank
fun.
you guys for watching. And remember, subscribe. And if you have comments, you have thoughts, leave them in the comments. We actually do look at that. There hasn't been a ton, so it's easy to get through.
Such interesting content.
All right. Thank you guys.